Okay, I have to, every time I open this up, it always installs an update. So I think I got past that screen. All right. Okay. Okay, the update's completed. Mr. Smithback, can you still hear me?
Yep.
Okay, let me turn my volume up a little bit. Okay, we'll call your case, we'll call this City of Stoughton versus Aaron Smithback. Mr. Smithback, do I still have your correct address at 813 Hilldale Lane in Stoughton?
1813 Hilldale Lane.
Correct. Okay, that's what I have. I just didn't say it correctly. Okay, you've been cited for, and this is the initial appearance tonight. The purpose of the initial appearance is for me to inform you of your citation, go through the elements and the penalties, and then I take a plea. Your three plea options are guilty, no contest, or not guilty, and I'll review that with you at as we get closer to getting a plea. All right. So you've had two citations. One is called operating with a prohibited alcohol concentration. The other one is operating while under the influence of an intoxicant. Now, both of these are referred to as what are called OWI, or even more common, drunk driving. Do you understand the nature of these citations?
Yeah.
Okay. Now, the elements are basically, for one, that you are operating while under the influence of an intoxicant. You're operating in premises held out for the public use or a highway. And you were operating motor vehicle on a highway or premises held out to public use while under the influence of an intoxicant. Do you understand those elements?
Yes, sir.
Okay. The other one was operating with a prohibited alcohol concentration. That means you're operating a motor vehicle either on a highway or premises held for public use with a prohibited alcohol concentration. That means you're above the legal limit, essentially. Now, you understand that as well?
Yes, sir.
Okay. In Wisconsin, first offenses are usually 0.08 for a non-commercial driver's license. Have you ever had an operating while intoxicated before?
No, sir.
So you received two citations, and let me go through the prohibited alcohol concentration first. The face amount of the citation is $861. Now, the citation ranges from $150 to $300. However, they add court costs and they add an assessment of $355. That bumps up the price to usually between $700 and $1,000. So you're kind of in the middle of the fine range. Do you understand that as well?
Yes, sir.
Okay. In addition, if you're found guilty, 6 points are assessed against your driver's license. Your driver's license will also be revoked if you're found guilty for a period of between 6 and 9 months. Now, the 6 to 9 months is usually dependent on a couple of things. One is your blood alcohol content. If you're below a 1.5, I usually issue a 6-month driver's license revocation. If you're between a 0.15 and a 0.2, it's 7 months. And if you're above a 0.2, it's 8 months. And if there's any bad driving, I usually add a month to that revocation period. Do you understand that as well?
Yes, sir.
So points, and then if you're found guilty, you must attend an alcohol and drug assessment as well. You understand that?
Yes, sir.
Okay. Now, if your blood alcohol content is a 1.5 or higher, the state mandates that I order an interlock ignition device be installed in all vehicles registered in your name for a period of 12 months. In addition, you also must drive with an interlock ignition device any vehicle that you might, there has to be an IID present in any vehicle that you drive. So the vehicles you own and the vehicles you drive for a period of 12 months, if you're 1.5 or higher. You understand that as well?
Yes, sir.
Okay, so I have to surcharge you $50 on the IID if you're a 1.5 or higher. You understand that?
Yes, sir.
Okay, so do you know what an IID is, an interlock ignition device?
Yeah, I do.
Okay, so I don't, basically a machine that you have to blow on it before the car will start, and it also does checks while you're driving. Okay, you're familiar with all that?
Yep, I am.
Okay. And those are the penalties for the prohibited alcohol concentration. Now, you received the second citation for operating while under the influence under the influence. That carries the same penalties: 861, 6 points, alcohol and drug assessment, a 6 to 9 month driver's license, and penalties if you're above a 1.5. Now, this gets confusing, but I can find you guilty on both, but I can only impose penalties on one citation. In other words, you received 2 citations, 861, 861. I can only fine you for the one 861.
Okay.
I can't double up on the citations. Basically, if you want to be found not guilty, you have to do, if you basically have to be, you cannot be guilty, you have to be found not guilty of both the prohibited alcohol concentration and under the influence of an intoxicant. But you only face one set of penalties.
Okay.
Okay, so any questions regarding any of the citation penalties?
No.
Any questions regarding what makes up an OWI or PAC?
No.
Okay. Now we're getting close to what when I take your plea. Your 3 plea options are guilty, no contest, or not guilty. Now, guilty plea means that you're accepting your guilt. And if you enter a guilty plea, I'll review the police report. If there's a factual basis, I'll find you, accept your guilty plea and find you guilty. You understand that?
Yes, sir.
Okay. A no contest plea means that you're not admitting guilt, but you want to get it over with, so to speak, tonight. In other words, you're not admitting guilt, but you want basically. You're not, no contest plea is usually used when, say, if you cause a traffic accident, if you enter no contest plea, you're not admitting guilt, so they can't bring additional, they can't use your guilt against you if they sue you in a later action, basically. So you're not admitting guilt, but you want to end it. And with a no contest plea, I still will read the police report. If there's a factual basis, I'll accept your no contest plea and find you guilty as well. You understand that?
Yes, sir.
Okay. And the not guilty plea means that you don't believe the city could prove their case, or that you should not be convicted of this, and you enter not guilty plea. And in that case, what I do is that I don't review the police report. I will schedule a pretrial conference with the prosecutor in order that you attend. And it's a chance with you to meet with a prosecutor to see if this case can be resolved before a trial. Understand that?
Yes, sir.
Okay, and if you're unable to resolve that, then it gets scheduled for a trial, and I'll hear all the evidence. Okay?
Yes, sir.
Any questions regarding any of the plea options?
No, sir.
All right, now is the time I take your plea. Your 3 plea options are guilty, no contest, or not guilty. What is your plea?
No contest.
Okay, you understand with a no contest plea, I'll review the police report. If there's a factual basis, I find you guilty. Do you understand that?
Yes, sir.
Okay, let me read the police report. I want to make sure I have a factual basis for your plea. It'll just be a minute. It's 17 pages long, so it takes me a little bit to read this.
Okay.
Okay, Mr. Smithback, I reviewed the police reports. I do find a factual basis for your plea. I'll accept your no contest plea and find you guilty. Anything you'd like to say before I decide on a sentence?
I just would like to say that I know that my BAC was quite high during this. However, I'd just like to ask if there's any anything we can do with the ticket maybe being reduced or anything. Seeing that I've had a clean driving record up to this point, I've had 0 tickets. I've never even been pulled over before. So just would wonder if you would consider that.
Okay, I would consider that. I will note that the blood alcohol content was high, it was a 2.5, but there was no bad driving, thankfully. And I let me take a look at your driving record that should be attached. Yeah, I will confirm that the driving record is clean. So because of that, because you asked for it, I will reduce your sentence. I will sentence you to a 7-month driver's license revocation instead of 8, and what I normally would give, just based upon your record and your, I can hear regret in your voice, and that you appeared tonight and wanted me to look at this as well. So the rest of the sentence, so besides 7 points, I have found you guilty. So it'll be 6 points will be assessed against your driver's license. I will, I find the fine of $861 to be reasonable. Mr. Smithback, how much time do you need to pay that?
I can pay it as soon as possible.
I'll give you 60 days.
Judge, are
Okay,
you going
thank
to add the IID fee?
Yes, I'm sorry. Thank you, Mary. So you're above a 1.5. So the state mandates that I have to order an interlock ignition device be installed on all vehicles registered in your name, and that for the next 12 months, when you drive a vehicle, you have to have an interlock ignition device installed when you drive that vehicle. Now, you can't sit this out. So if you don't drive for a year and then get your license updated, you still, that 12 months will begin when you get a what the DOT calls a product, either an occupational license or a regular license. You understand that?
Yeah.
Okay, so because there's an IID, the $50 is surcharge. So instead of $861, it will be $911, but I'll still give you 60 days to pay that.
Okay, thank you.
Okay, so 6 points, $911, AOD requirements, 7-month driver's license revocation, and then IID for 12 months, and then 6 points. Okay. All right. What I'm going to do is my clerk, Mary, is going to actually mail you the assessments form. Please complete that. And Mary, you'll need a copy of that back, correct?
No,
Oh,
No.
okay.
no, we don't.
So you will send the assessment, but make sure that when you have the assessment, there's a number for you to call. Call that number as soon as you get our paperwork.
Okay.
You're supposed to call within 72 hours of the court date. That's not going to happen because of just COVID and the mail delay. But call as soon as you get that number and set up assessments. What happens is with the assessment, they'll determine if there's any alcohol issues, and they'll schedule counseling. You have to attend it's called the driver safety plan. You have to attend the driver safety plan before you get your driver's license back.
Okay.
Even if you've been revoked for 7 months, but if you haven't completed the driver safety plan, you'll be unable to get it. So we'll also send you information on an occupational license and a copy of the conviction reports as well, because I found you guilty of both citations. So we'll mail that to you. That's why I asked for your address in the beginning. Okay.
Okay.
Any questions regarding the assessment?
No, sir.
All right. Now this is being video recorded, but I must ask, what did you learn from this incident?
Definitely learned that it is never acceptable to get behind the wheel intoxicated. And I made just a bad decision that night. So
Okay.
I've learned definitely that this is not a way to go.
Because it's very dangerous, and if you get another one within 10 years, you'll be facing criminal penalties, including mandatory jail.
Yes, sir.
Something to keep in mind. Okay. Well, any further questions?
I have one question. So let's say I get an occupational license, does that 12-month IDD requirement start there?
Correct. The occupational license will require that you equip your vehicle with an interlock ignition device.
And then the 12-month duration starts with that
Right. From what
occupation.
I've been told with the Department of Transportation is once you get a product, and that includes an occupational license, that's when the 12 months start.
Okay.
Okay. So with no further questions, we'll send you all the documents, and there will be a number for you to call. If you have any questions after you get the documents, feel free to give that number a call. Otherwise, that will take care of it for this evening.
Okay. Thank you very much.
All right. Thank you, Mr. Smithback.
And then we have Hannah Fish, and I'll bring her in from the waiting room.
Okay.
Uh-oh, I think she may have left.
Okay.
Huh? Yeah. Oh, no, there she is. Sorry, there she is. All right.
Miss, is this Hannah Fitch? Are you present?
Yes.
Okay. I can, oh, there you are. Okay, now I can see the video. I never know who's going to appear by video or by phone. All right, Ms. Fitch, let me pull up, I've got the police reports on a separate page. Let me pull that up. You can still see me, but I can't see you when I go onto the screen. Okay, Ms. Fitch, do I have your correct address on Sherrill Parkway in Fitchburg?
Yes.
Okay, you received a citation for speeding on a city highway 11 to 15 over the limit. Do you understand what speeding on a city highway is?
Yes, sir.
Okay, and you understand that the city is alleging that you were going 11 to 15 miles an hour over the posted speed limit?
Yes, sir.
Okay, this citation carries a penalty of 4 points and a forfeiture of $98.80. Now, $98.80, that's $30 plus costs. The forfeiture range on these citations are $30 to $300. You're actually at the minimum forfeiture possible of $30 plus costs. When you get these citations, some of it goes to state and jail crime lab fees. There's a bunch of others. When you get a citation, there's a lot of different buckets that we have to pay, basically. It's the county and the state, and then the city collects a little bit of extra revenue. So the $30 turns into a forfeiture of $98.80. Do you understand that?
Yes, sir.
Okay. Now, I have a policy for speeding that if you were enter a not guilty plea and meet with the prosecutor, they give you a 10-mile-an-hour leeway, and they've given me discretion to do the same. So instead of 11 to 15 over the limits, I could reduce this to what's 1 to 10 over, which would be 3 points instead of 4. Same forfeiture of $98.80. So it essentially saves you a point. And it would look as, there's 3 different types of speeding classifications. There is the simple speeding, 1 to 10. There's intermediate, which is 11 to 19, which is 4. And there's 20 or more, which is 6, and that's called excessive. So what I'm doing is I'm moving you from the intermediate speeding classification to the simple speeding, the most lenient. That's usually my policy. You understand that as well?
Yes, sir.
Okay. So we usually take pleas for it's plea night. In plea night, you have 3 plea options. One is guilty, that you're admitting your guilt. And this would be from speeding 1 to 10 over. Speeding that you're admitting your guilt. The second plea option is no contest, meaning that I don't want to admit the guilt, but I want to end it today. And then you're not admitting guilt, and I would treat it that you're not admitting guilt, but I can still find you guilty based upon a no contest plea. Your third option is a not guilty plea. You want to have basically take this matter to a trial, or you want to speak to a prosecutor. If you enter a not guilty plea, I schedule this matter for a pretrial conference with the city attorney. It used to be in person, now it's via Zoom or by phone call. I think it's by phone call. Chance to tell where you and the city meet, and I order that you attend this to see if your matter can be resolved short of a trial. Okay, do you understand your 3 plea options?
Yes, I do.
Okay, any questions for the court?
No.
No. Now's the time I take your plea. What is your plea to speeding 1 to 10 over the limit?
Guilty.
Okay, you understand with a guilty plea, if you enter a guilty plea, I must find you guilty? Is that a yes?
Yes.
We're being recorded, so it has to be out loud. So although it's better that I can see you and it's nodding, but I want to make sure that I establish a record then. So
Yes.
all right. I'm going to go to the other screen. Let me read the police report. I want to see if there's a factual basis for your plea. Okay, Ms. Fitch, I have read the police report. I do find a factual basis for your plea. I'll accept your guilty plea and find you guilty of speeding 1 to 10 over for 3 points and a forfeiture of $98.80. Anything else you'd like to say?
No.
That's fine. I will give you, Mary, how much, I usually give what?
60.
I'll give you 60 days to pay. We'll send out that correspondence to you at the address that's on the citation. Once you get that, you have 60 days or actually 60 days from tonight, but that will include instructions on how to pay your citation.
Perfect. Thank you so much.
Okay. Any other questions?
Nope, that's it.
All right, that will take care of it for this evening. Thank you for appearing via Zoom.
Thank you.
All right, have a good night.
You too.
Okay, do you want to run through the rest of the initials?
Yes.
All right, I got the updated plea sheet, so that helps kind of run through these. All right. First one is Nolan Baker, bond forfeiture. Next is Seaham, can't even read this, Seaham Banat, and it says C plea sheet. So I will go ahead and open up the plea sheet. Okay, basically it's just mea culpa and they're sorry. I accept their plea, but they agree to plead no contest. I'll accept their no contest plea and find them guilty and then impose the face amount of the citation. Okay, next is Joel Bratland is a default judgment on all 3 citations. Christina Carroll is a default judgment. Michael Chipman is a default judgment. Done Dorenzo is a default judgment on both citations. Thomas Drierson is a default judgment. Michael Emberson is a default judgment. Bruno Esponzan Lima is a default judgment. Jesus Espinoza Morocco is a default judgment. Corey Finfrock is a default judgment on both citations. Austin Fisher is a bond forfeiture. Ms. Fitch has just entered a guilty plea. Geraldine Foy is a default judgment on both citations. James Hammis is a default judgment. Andrea Hernandez is a bond forfeiture. Preston Hindis is a bond or default judgment. Daniel Hoffman is a default judgment. Paul Hutchinson is a default judgment on both citations. Jacob.
I'm sorry, Hutchinson is a bond forfeiture.
Oh, you're correct. Thank you. Bond forfeiture. My apologies. Okay, and Jacob Kopke is a let's see, we'll accept the no contest plea that the defendant entered for both citations. Ernest Klatt is a bond forfeiture. Ethan Cloudis is a default judgment. Brock Kocherer is a bond forfeiture on both citations. Andrew Mathis is a default judgment. And again, for no hold open the issue of restitution for all these retail thefts. Christopher Minner is a default judgment. Alexander Monroe is a default judgment on both citations. Gregory Moratz is a default judgment. Kaya Nachagal is a bond forfeiture. Lasquasho Nunn is a default judgment. Joshua Phillips is a default judgment on both citations. Karen Puskas is a bond forfeiture, and then we have one with a plea sheet. Let me go back to the plea sheet page. Oops, I clicked on the wrong button. Sorry, Mary. All right. Okay, it's a statement saying that the insurance was in the car and stuck to another piece of paper. And I see the document confirmation. Let me check. I think if, let's see, how much was the forfeiture? It's a $10 forfeiture. What I will make the findings, Mary, that the defendant has supplied adequate proof that they did have insurance, and the court on its own motion will dismiss the citation.
Okay.
Next is Mary Rip is a bond forfeiture. Daniel Rose is a default judgment. Mary Shield is another plea sheet. I thought there were only two, so let me take a look at this one.
We just have the police sheet online now, so they can complete
Right.
it and send it, so it helps being able to read.
Okay. Said no contest, but believe the officer overestimated her speed. All right. Let me take a look at the police report. I'm having trouble reading the attachment. What was the speed of the
16 over,
16 over?
yes.
Okay, what I will do is I will reduce this to 1 to 10 over in 3 points instead of 4. Same forfeiture amount with 60 days to pay.
Okay,
Essentially, the plea sheet was asking for reduction in forfeitures or reduction in points, and I'll honor that request. Next is Jason Schuett is the default judgment. Tobias Schultz is the default judgment. Carly Springer is a default judgment. Jacob Swenson is a default judgment on all 3 citations. Emily Symes is a default judgment. Michael Toby is a default judgment. Jared Torblu is a default judgment. Sean Vandermerwe is a default judgment. Jeremiah Velasquez Funes is a default judgment. Brennan Wiesner is a default judgment on both citations. On 3 citations, excuse me. Last one is Tyler Wilberg, and that is a default judgment.
that's it.
Okay, and I got the trial. You saw the trial notice that I went ahead and approved the
Yeah,
settlement
yeah.
arrangement. Okay, last court session of the year. Thank you, Mary.
I'll be sending you an email about our next court night. It's the juvenile night in January.
Okay.
Just to give you a heads up of what's going on with that, with the school. So,
Okay. Oh, yeah, the questions with that, and just probably be good to have an update then, so, okay,
yeah, we'll have to decide what to do about our sentencing agreement,
okay.
how that would apply. So,
Okay.
all right, that's it.
Thanks, Mary. Happy New
I'll
Year,
talk to you.
and I will see you next year.
Okay, thank you.
Thanks, Mary. Bye.
Bye-bye.